Hello and welcome back to the channel. Today we'll be discussing about how to register a trademark in Mauritius. Trademark registration in Mauritius is done by the Industrial Property Office of Mauritius, and exclusive rights over the trademark are granted to the proprietor for a period of 10 years. Trademark registration in Mauritius is governed by the Intellectual Property Act of 2019, which lays down the various aspects of trademark registration in Mauritius. Step 1 involves designing of the trademark. The first step in the process of registration of a trademark is the designing of the mark. The mark should be designed in such a manner that they are distinctive signs that are capable of distinguishing their services or products from those of the others in the market. Trademarks in the form of words, numerals, letters, drawings, pictures, colors, labels or combinations of these can be registered as trademarks in Mauritius, provided they do not fall within one of the categories of marks that are prohibited. A trademark should be either a service mark, collective mark, certification mark, etc. Step 2 involves determining the classification of the services and goods to be trademarked. It is necessary to keep in mind that the services and goods for which the trademark is being applied should be clearly listed in the niche classification for the international registration of goods and services. The application should consist of all the services and goods which you want to receive for your trademark. The niche classification is classified into 45 classes, out of which 1 to 34 are related to the goods and 35 to 45 are related to the services. Step 3 involves undertaking a prior trademark search before filing the application. It is not mandatory for a proprietor to conduct an online search before filing the application of registration. However, official trademark availability searches are available before the filing of the application. Prior to filing an application for trademark registration, it is advised to conduct a trademark search to find out whether a similar mark or design already exists with the same name, and also to prevent chances of infringement of an existing trademark. The prescribed fee for the trademark search is 300 Malaysian rupee, which is approximately $7 US. The trademark search can be conducted at the Industrial Property Office of Mauritius between 9:30 AM to 14:30 PM upon payment of the set fee. A proprietor must always remember that merely searching the database and finding the results to be okay does not mean that the trademark can be registered. The office also conducts a trademark search on its own after filing the application and reviews it before accepting or refusing the application. Step 4 involves filing the application for the registration of a trademark. The following formalities have to be completed before filing an application for the registration of a trademark in Mauritius. The proposed mark has to be clearly affixed in the space provided in the heading. Representation of the mark in the application, along with one reproduction of the mark, has to be submitted in this soft copy. If there is any figurative element in the mark, then it has to be clearly identified and the correct title of the mark has to be inserted. The services and goods for which the registration is being sought have to be correctly and clearly listed under the niche classification for the international registration of goods and services. The application has to be accompanied by the prescribed fee, which is 6,000 Malaysian rupee, which is approximately $135 US, and the fee prescribed for every additional class filed in the application is 2,000 Malaysian rupee, which is approximately $46 US. The prescribed fee has to be made to the government of Mauritius via check payable, cash, credit card or debit card. In case the applicant's ordinary residence or principal place of business falls outside of Mauritius, then the applicant has to be represented by an approved agent or a legal practitioner residing and practicing in Mauritius. In case of foreign resident who is residing in Mauritius, proof of residence or any such document acceptable to the office has to be provided. If the mark or characters proposed is in a foreign language, then a transliteration and or a classification of the mark characters has to be submitted along with the application. The certificate of incorporation or any other supporting document is required to be filed in case the application is filed in the name of the legal entity or a company. The registration of a trademark confers upon the registered proprietor the exclusive right to use the trademark and prevent any unlawful use of the same. Step 5 involves examination of the mark by the Industrial Property Office of Mauritius. The examination of the trademark applications is undertaken by the Industrial Property Office of Mauritius, where it examines whether the information required for filing an application for the registration of a trademark is complete or not. It also examines whether the proposed mark meets the definition of a trademark or not. If the director finds any deficiencies in the application in terms of furnishing the required information, he shall request the applicant to furnish the additional information, or he may be asked to amend the application within the prescribed time period. If the application fails to comply with the request made by the office, the application shall lapse. Step 6 involves publication of the applied mark and invitation for oppositions. If the director finds that all the requirements to file the application for the registration of a trademark have been met by the applicant, he accepts the application and causes it to be published in the Gazette. Any person can lodge an opposition with the director regarding the trademark on payment of the fee within the prescribed time period. The person lodging the opposition has to file it in the form of a notice and state the grounds of opposition. The applicant has to send to the director and the opponent a copy of the counter statement to the opposition along with the grounds on which the applicant has relied. Not filing a counter statement by the applicant shall be deemed as an abandonment of the application by the applicant. After receiving the counter statement, the director hears both the parties and decides whether the mark is supposed to be registered or not. After the publication of the mark and until the registration of the mark, the applicant has the same rights and privileges which he would have if the mark had been registered. In case the director refuses the application, the same shall be notified to the applicant in writing. The applicant has a time period of 6 months from the date of receipt of the notification from the director to make written representations before the director to reconsider the application for the registration of the mark. Where the applicant fails to make the written submissions within the time period of 6 months, the application for the registration of the mark is deemed to have been abandoned. The director has to inform the applicant about his decisions and reasons thereof within a period of 1 month from the date of receipt of the written representation from the applicant's end. Step 7 involves registration of the trademark. Where the director is satisfied with the particulars of the application and the application has not been opposed by anyone within the prescribed time limit, or the registration of the mark has been opposed and such opposition has been decided in favor of the applicant, the director shall register the mark and publish its details relating to the registration. Finally, the director issues the applicant a certificate of registration. Let us now discuss the information to be furnished in the application for trademark registration in Mauritius. The application for the registration of a trademark in Mauritius is to be submitted to the Director of the Industrial Property Office in the prescribed form, accompanied by the payment of the prescribed fee. Following information is supposed to be furnished at the time of filing an application for trademark registration in Mauritius. The representation of the mark, where applicable, a statement indicating the type of the mark and specifications applicable to the type of mark. The services or goods claimed in the mark, priority claims if applicable, name and address of the applicant and such other information that has been prescribed, the list of services and goods for which the registration is sought, grouped in accordance with the applicable class or classes as per the niche classification, details of the legal practitioner appointed or the registered patent appointed, and the nationality or place of business of the applicant. For more such information, please subscribe to the channel.